Good afternoon, everyone. Can you all hear me? I'm feeling a bit fluish, so my voice will fade a bit, but I'll try to project it accordingly. I just want to say how honored I am to be presenting to you ladies this afternoon. I mean, you can imagine. And men, sorry. To be presenting to you this afternoon. And you can also imagine how nervous I am having to speak after Desiree, someone I grew up watching on TV. And I'm just an attorney. I'm a legal counsel for Barclays Africa. Also,
just an attorney.
Thank you for pointing that out. So I'm truly honored. And I also want to acknowledge the young ladies in the house, the learners from Ezenzo Mazi Community College. I'm very passionate about youth empowerment, and I get very emotional because I can imagine, or I still remember how I was so full of dreams when I was your age. And I mean, I was born in the early 1970s. I wasn't born, as we refer to you guys, the born frees. You guys have endless opportunities. I mean, like today, you're here, having listened to all this amazing presentation and amazing motivational speeches. So I just want you to encourage to have and live your dreams and have the vision and have the focus. And I also want to thank Juju and Busara Leadership Partners for giving me this opportunity today to come present. I mean, people that know Juju, she makes you think out of the box. I mean, she said to me one day, Wyna, I want you to come and do a presentation. And I said, but what am I going to talk about? And then we played around with ideas, and I'm really glad that you pushed me and so that I can do this presentation. What I'm going to talk about, like my husband, when he reviewed this presentation, he said, Wyna, it's too legalese. And since I've also taken account that I have to stay away from the jargon, I will try to do that. And Non-Denisa also warned me, the ladies, try to speak in English. So I will, but as you know, for every successful woman, successful man, for any person that wants to achieve certain things, there has to be an attorney behind to advise accordingly. So you have to pardon my presentation, and I made them a bit detailed because I was also advised that the presentation would be on the Sarah Leadership Partners website so that you can refer to it later on. The topic for today, as I've highlighted, is protecting one's personal and business assets. And I'm glad that I was moved right at the end. I wasn't initially happy when I was told I've been swapped around because I wanted to get my presentation right at the beginning over and done with. But having listened to all the speakers, I mean, it's all about encouraging us to live our vision, to live our dreams. And having chatted to some of the ladies, I mean, already you're living your vision, like you've got your own companies that you're running with. Some of the ladies, you still want to pursue that vision. And today I'm going to try and help you. What are those legal entities that you can use to start up your business? A typical question that you always hear is, I'm married, and you could be married in community of property, out of community of property, with or without accrual. I mean, for instance, if I can maybe just, I love using personal stories, so if I can use myself as an example, I mean, the deciding factor for my husband and I when we got married in terms of the marital regime that we decided was that we are going out of community of property with accrual, just in case in the future, one of us would decide to pursue a business, and God forbid something happens to that business, it gets liquidated. We have to have something to fall back on. So hence, the marriage out of communal property. And it's not because we didn't love each other, but we had to be practical about that decision. And I know it's having spoken to some of my friends, they give you a funny face, but out of communal property, and I say, it's not, it was not even a debate. We had to make practical business decisions with regards to that. So depending on the type of marriage, and nowadays, I mean, I've got two colleagues that I work with that are doing extremely well, but they decided they're not going to get married. They are cohabiting, or you could be single and you want to start a small business. So my objective for today is just to highlight some of the options that you have out there. And being the attorney that I am, I'm just going to have a disclaimer that this is not legal advice. I'm just going to give you a general overview. Should you require advice, legal advice, you can call me up, or I can hook you up with someone that can provide proper advice on that. Okay? Without wasting time, let me move back. In your view, what are the major considerations that one has to take into account when you want to start up a business? Some suggestions just to kick off the discussion?
I think you want to limit your personal liability.
Absolutely, absolutely. Protecting your personal assets and business assets is very critical. It's very vital because you don't want to end up in a situation where, like the business go bust and your personal assets, your residential home that your husband and yourself have worked on, and maybe if you're married in commercial property, gets attached and you lose all of that. So finding an entity that would give you that protection is very important. What other consideration that are also important as providing security? Any takers? Okay, let's just go through them. Source of funding. I mean, it's very important. Are you going to go to the bank to get funding? Are you going to bring along two of colleagues that you've worked with and you believe in them, that the combination of yourself and your colleagues can bring an amazing company? The nature of, or the level of borrowings, as I've indicated, is very important. The number of parties that are involved in the business is also very important. And what's also important is the nature and extent of the business. I mean, that's a no-brainer. What type of company do you want to go into? The other important thing that people disregard or forget about is the desire to provide perpetual protection. On your death, what is going to happen to that business? Because a sole proprietorship will look at that later on. I mean, it's so intrinsically linked to the business. So should founder of that business die, the business also will cease to exist. Attached to that, or to that point, is the likelihood of the business being sold is a going concern in the future. We also have to take that into account. And as one of the ladies indicated, the limit to personal liability, I cannot overemphasize this, ladies. It's very, very critical. And what's also important is the extent that the entity or the business that you're going to go into is regulated. Because the cost of compliance can be very high. I mean, I work in financial services, particularly in banking. We are highly, highly regulated. Starting off then with the options that you have if you want to start up a company, a business. It's what we call sole proprietorship. Sole proprietorship is one of the easiest entities that you can start because there are no formalities that are involved at all. All is required is to obtain that relevant trading license. For example, if you want to go into sorry to use liquor, in the liquor business, you would require a liquor license for that. And a sole proprietor will have to register for tax because you have to pay tax on the income that is generated out of that business. And should your income from the business exceed a certain threshold, you have to register for VAT. However, many entrepreneurs, and as we've highlighted, it's very risky to trade as a sole proprietor because it's not separate legal entity. What I mean, the sole proprietor and the business are one and the same thing. It does not offer that risk. However, some sophisticated entrepreneurs transfer their assets into a trust to protect those personal assets from being untouched by creditors, and we'll look at that later on. So what are the advantages of operating as a sole proprietor? I mean, we've already highlighted the major disadvantage, which is it's highly risky because personal assets are not separate from the assets of the business. They can be easily attached by the creditor. A sole proprietor have no business partners. You are your own man or your own woman show. You can direct the business in any manner. You don't have any board of directors that you need to account to. All the income and the profits of the business accrue to the sole proprietor directly. You don't have to declare dividend to anybody. And when a sole proprietor wishes to cease business, there are no formalities other than settling unpaid liabilities of their business. And what is also important is that a sole proprietor can take out life insurance, on the liabilities of the business. Should anything happen to that sole proprietor, at least the heirs and the legatees, will be able to obtain all the assets of the underlying business without any incumbent by liabilities. The other thing that I've indicated to earlier on is that the sole proprietor would have to pay the tax and the capital gains tax, that's what it means, CGT, capital gains tax, in their own personal capacity because they're not separate from the company. And what you have to take account of is that the higher the profits or the more successful the sole proprietorship is, the higher the income that will be generated. And as an individual, you could be sitting at 40% in terms of the tax rate, whereas a company pays 28%. So those are the considerations that one has to take into account. Disadvantages, we've already touched on this. Sole proprietor is not separate from the business, so that intrinsically linked. Personal assets are not protected. However, as we'll see later on, a trust can be used in that instance. The licenses and goodwill are linked to the business, so in the case of death, that business will come to an end. And the other thing, there is no employer-employee relationship because the business and the sole proprietor are one thing. So things like pension fund cannot be provided to the sole proprietor. However, the sole proprietor can have a pension, and I see we have our pension fund adjudicator in the house. So a pension fund can be provided to the employees of the sole proprietor. However, things like retirement annuity can be taken out. Continue with the disadvantages. It's not always easy to sell or otherwise dispose of the sole proprietorship because, as I've indicated, once the owner dies or the founder, the goodwill of that company also goes with with the founder. So what is the next option that's available out there, ladies? It's a partnership. A partnership is a legal relationship between two or more persons, and that's very important, who are bound to contribute to the common purpose of the business. I mean, we each agree that we're going to come together and we each going to contribute towards the running of that partnership. And your contribution can either be skill, labor, or funding. And besides having a partnership agreement in place, there are no other formalities that are required. And it's very important also to emphasize, ladies, that for a partnership to be a partnership, there has to be an agreement in place on how the profits of that partnership are going to be divided between the partners. Because if there's no profit sharing, it's something else. It's not a partnership. So that's a legal requirement. The essentials, we've already touched on it. Valid contract of partnership has to be in place. Each partner must make a contribution, and the objective of that partnership is to make profit. If it's non-profit making, then it's not a partnership. It would be a non-profit company. We will touch on the non-profit company later on. And the business venture should be carried on for a common interest. And the common mistake that people always make is that the partnership should subsist for a long time. I mean, we could agree with a colleague that we're going to form a partnership for a certain limited period of time, which is different from a firm of attorneys, which are incorporated partnerships. We'll touch on them when we look at companies. So this is an exception where a partnership, even though it's not a separate legal entity, it is incorporated and it has that recognition as a separate legal entity. Okay. What are the characteristics of a partnership? It's not a juristic person like a company, where a company is separate from its shareholders, and we'll touch on that later on. The partner and the partnership are one and the same thing, just like a sole proprietor. It doesn't offer that protection. Your personal assets are the same are the assets of the partnership, just we've seen with the sole proprietorship. The partners, they own jointly the assets, and they are severally and jointly liable for the liabilities of their partnership. What I mean by that, if I can speak in English, is that if I'm a third party and I have entered into a contract with that partnership, I can decide that I go after that partner because she looks pretty, she drives the fancy car, so she must be the one that has all the money to pay for my damages. So each partner is jointly and severally liable for the liabilities of the partnership, except for what we refer to an in-commandite partner. An in-commandite partner is it's a secret partner. Basically, they fund towards the partnership. However, they're not involved in the day-to-day management of that partnership, and their exposure is only limited to what they have put in that partnership. Rights and duties of partners. They share in the profit. They participate in the management and the control of the company. I mean, they are each contributing towards this partnership, which is very important. They have a right to claim division of assets at the division of the partnership when the partnership comes to an end. They have a duty to contribute towards the partnership as agreed in the partnership agreement, and very important as well, they share in any loss, and they must always act with due care in the partnership affairs. And what we call in legal, they have the fiduciary duties meaning they have a duty to always act with loyalty, always in good faith, always acting in the best interest of that partnership. That's what fiduciary duties mean. And a partnership can come to an end by agreement, could be written or implied, or by operation of law, or as I've indicated, at the end of a specified period. I'm not going to spend too much time on partnership, as like a sole proprietor, that each accountable for their own taxes. So depending on the income of that partnership, an individual partner will pay tax on their individual tax rate. Could be it ranges from 18% to 40%. Something that offers us the protection that we need, meaning your personal assets are protected from the business assets, is companies. A company is a separate legal entity with full capacity. What does that mean? It means that it can act in its own capacity, it can sue, or it can be sued. So the shareholders would not be involved in being sued personally, but we'll see later on directors, and looking at the caliber of women that we have in the room. Some of you might be sitting in some of the boards, so it will be important that when we look at fiduciary duties of the company, to also take note of some of the legal risks that come with being a guarantor. A company owns its own assets and liabilities. Very important. Even though you've started the company, that company does not belong to you. The assets do not belong to the shareholder. And what you need to start up a company, and there are formalities involved. You have to register a company with the Company and Intellectual Property Commission. We commonly refer to that commission as CIPC, some say CIPS, the old CIPRO. So that's where you need to register your notice of incorporation to start the business, or your memorandum of incorporation. Your memorandum of incorporation basically will provide the objective of the company, what are the powers of that company, the powers of the directors as well. And if you have a share in the company, what does that entitle you to? It entitles you to dividend, and very important, I've underlined the word only. It's not automatic. Dividend is not automatic. It's only when it's declared. And the other important thing, and which I think as shareholders in some of the companies is very important, you have a vote at shareholders meeting. I mean, we read about Theo Botha. We know how active he is at AGMs. I mean, he takes the board of directors on very critical issues like executive remuneration. So we also have to have that spirit that Theo has as a shareholder, challenging some of the decision of the board. So what type of companies are out there? I just need to point out that we have a new Companies Act that came into effect on the 1st of May 2011, and it provides for two broad categories of companies, namely a non-profit company that I assume Green Flip-Flops operates out of. It's an NPC. It has been duly registered with the IPC. A broad category is a profit company, and I've also heard other ladies saying, oh, I want to start up a company. So we have a state-owned company, so obviously we can't start with this one, the state-owned. It's your ESCOM, for example, your SAA, and they are governed by a different piece of legislation, the Public Finance Management Act. We have a private company, public company, and personal liability company, which are the old, like what was referred to as the incorporated partnership. I've touched on general partnership. However, we have a special category of partnership that caters for professionals like attorneys, which are regarded as personal liability company. What that means is each partner is jointly and severally liable. And the other important thing to note of, because I know the flexibility that close corporations used to offer to people that wanted to start companies. With the effect of the New Companies Act, you are unable to register a new close corporation. However, those ones that were registered before, they still subsist. However, from the 1st of May, no new close corporations are available. You can only open up a private company. Looking at a public company, they're identified by the word limited or abbreviation limited, and the shares of a public company, and I believe most of us that are in employment, we are shareholders in most of the public companies that are listed on the Johannesburg Stock Exchange, because our pension monies are invested in those companies. So a public company can freely transfer its shares to the public, and as I've indicated, they trade via the stock exchange, and they have to comply with stringent JSE listings requirements. With regards to corporate governance, they must have a minimum of 3 directors. Minimum meaning they can go higher. The business and affairs of the company are managed by the board of directors, and the directors owe a fiduciary duty. I'm going to pause here because I think as a legal counsel, I need to just indicate how important it is to take our directors' duties very seriously. In this day and age, given the new provisions of the Companies Act that provide for liabilities of directors in certain instances. I mean, the Companies Act provides in section 75, if I can just be pardoned for using jargons and sections, provides that as a director you need to disclose your personal financial interest. And it doesn't only talk about your own personal financial interest, but it also talks about personal interest of your relatives. So it goes even further. So it's very, very important that we give the due care and diligence in the functions that we perform as directors. Failing that, there are liabilities as provided in the Companies Act. A public company needs to have annual financial statement that need to be audited, and that financial statement would be presented at the annual AGM, annual general meeting. The company must apply the principles of King 3 Code, which normally would provide the type of directors that you need to have. We'll talk about independent and non-executive directors and so forth. I'm not going to touch on that because it's a topic on its own, corporate governance, but I'm just highlighting some of the things that we need to take note of. What are the advantages and disadvantages? I didn't focus a lot because most of us would not be operating public companies, except as directors or employees of that public company. They have clear corporate governance structures. That's why some of us are still in employment. We need to provide guidance on how those companies are governed. And if you have proper corporate governance structures in place, now we talk about integrated reporting. You're not only reporting on the finances of your company, you're also reporting on the impact that the company has on the environment and the community. So the more clear corporate governance structure in place, the more investors will have confidence in investing in your company. And as a shareholder, you can reap greater rewards by investing in a company that has clear corporate governance structures in place. However, the downside is highly regulated. A private company, very easy to form. You also have to register with the CIPC. It can be identified by the words proprietary. It's not proprietary, it's proprietary. It was the typo, limited, and with the abbreviation PTY limited. And unlike a public company, it cannot trade its shares publicly. So no offering of its shares or securities are to be made to the public. With regards to corporate governance, it must have a minimum of 1 director. However, for proper corporate governance, and depending on the nature and the extent of the business, it's advisable to have at least 3 directors to ensure that there is that balance in terms of powers. Just like a public company, the affairs and the business of that company are managed by the board of directors. The other point that I want to highlight, and that's why I have it in bold there, it's not a problem with big corporations that are listed on the JSE. However, if you are a director of a company, you are exposing yourself to huge risk, because in terms of the Companies Act, one of the sections says any person can sue the company. So if, and in certain instances, a director is jointly and severally liable for the liabilities of that company. It's important, and this is a query that I get on a daily basis, because with the organization that I work for, we've got a lot of subsidiaries, and we've got a lot of our employees that are sitting in those subsidiary boards. Wyna, am I covered? Do I have indemnity insurance? So what do I mean by that is that should anything go wrong, I mean, no matter how diligent we are in running the affairs of that company, things do go wrong, and just like a partnership, people go for partners that they think will have money to satisfy that claim. Ensure, before you sign that consent form to be a director, ensure that you have indemnity cover in place. Very, very important. And the other less stringent requirement with private companies is that their annual financial statements are not audited. They are independently reviewed, which is a less stringent requirement than audit. And they're also not required to have an AGM. And very important, ensure that the shareholders' agreement is very clear in terms of things like a quorum, like of directors meeting. Should there be no agreement between the shareholders, what is the way forward? Emma, how am I looking for time?
You're fine.
Okay. My personal entity that I like, maybe given that I enjoy tax law and it offers some tax benefits, or it used to. Every year there is something in the budget speech that the Minister of Finance will provide or say, we need to cut, like in terms of the trust benefits that are offered. A trust, it's a legal relationship whereby the creator, which is normally referred to as a founder, a donor, a settler, they must divest themselves of that property, and they must give it to a trustee who will have a control of that asset, and it is for the benefit of third parties. Guys, I cannot overemphasize this. As I've indicated, I love trust because of the tax law background that I have. Rather than trust, I'm not a critique of our Honorable Mr. Malema. I'm just saying, as people like to say now, I'm just saying, we should have trusts that are properly governed, that have trustees that are in control of the assets of that particular trust and are not acting as puppets. Because if that is the case, then your revenue service will be behind you, will look through that structure that you so-called a trust, and will tax whatever income that is generated out of that trust in your own personal capacity. So what are the characteristics of a trust? Just like a company, the assets and liabilities are owned by trustees and not beneficiaries. So a founder will divest themselves of this property and give it to the control or administration and ownership of trustees, and not beneficiaries. Beneficiaries just get to benefit from any income in the trust, or any capital arising out of a capital asset of the trustee. However, I don't want to get too legalese. We have what we call a within trust, and our Trust Property Act does provide for that, where ownership automatically vests with the beneficiaries, but I'm not going to go into detail on that. And what is also very important, if you are creating a trust, and I mean, we are sophisticated modern women, we want to leave legacies to our children. It's important that in the trust deed it's clear in terms of what discretion do the trustees have. Do they have discretion to distribute any income or capital of the asset of the trust, or they don't have any discretion? So we would normally refer to that as a discretionary trust or non-discretionary. So if there are minor children involved, I mean, it's best that you leave the discretion for distributing any income to those minor children to the trustees, for the trustees to make that decision. And the other important thing that I need to mention is that trust can be created in two ways. It can be provided for in your will, that on my death I need my assets, if you are married in community of property, your half of your joint estate to go into a trust, and that is referred as a testamentary trust. However, if you form a trust during your lifetime, it's called an inter vivos trust. Some of the essentials of forming a trust, and I've already touched on that, there must be clear intention by the founder that I'm letting go of the control of that trust assets that I'm putting in the trust, and I'm allowing the trustees to have the relevant and the necessary powers to govern that trust. The object of the trust must be lawful and sufficiently clear. The trust property as well, very important, must be defined with certainty together with the beneficiaries. They must be ascertained or ascertainable, and the trust property must be made over or bequeathed. And just to highlight, when you are selling, for example, that asset that you have in your personal capacity to a trust, there could be some income tax implications, and you need to get appropriate advice of what is the best method of transferring that asset from your personal capacity into a trust. Legalities around forming a trust. All is required is a trust deed, which have to be registered with the master. And as I've indicated, very, very important to have in your trust deed a clearly defined rights and powers of trustees. And in my example, when I was preparing my presentation, I didn't think that Augustine would be in the house. But the example that I wanted to use was the Mandela Trust, like the dispute around that, because Augustine's husband is one of the trustees. With trust, it's always very tricky. Like you need to have, good legal minds drafting that trust deed to ensure that the powers are very clear. Should there be disputes in the future, and I mean disputes are bound to happen, and that like you have a clear document that details these are the rights and obligations of trustees, of beneficiaries. So that's very, very important. And the master might require certain information For example, they might require the trustee to provide security. However, okay, moving swiftly along, just for the sake of time. 2 minutes, okay. Some of the pitfalls that I've already highlighted was around family trust. You form a family trust, however, you're still holding on to the control of the trust property, and you don't allow the trustees to have that control. So for revenue purposes or income tax purposes, that trust would be disregarded completely. And the other impact that it will have on your death, even though you've used a trust to protect an asset growing, an asset that grows in value, it might be disregarded and will form part of your estate. I just want to touch on the benefits of a trust because I think it's very, very important that we take note of this. It's an estate freezing. I mean, we are, Juju highlighted, like we are in process of, transition. We're evolving, we're getting greater, like this greatness. Now you might not maybe have a lot, but in 10 years' time, you could have been so successful. So, like a trust offers that benefit. You transfer an asset that you would think would have this future growth. It also offers protection against creditors. So should you be running a not a close corporation, a sole proprietor, for example, and your creditors might not be able or will not be able to attach your private asset in the trust. And I think this is what your silver Ramaphosa's of this world, some of their trusts, are holding shares in companies on their other beneficiaries. So it can also be used, a trust, for holding shares and members' interest. We normally refer to trust babies. I mean, trust babies, basically, they have parents or great-grandparents that had the foresight of putting valuable family treasures in a trust, and it offers protection from bad marriages. People marry you for the wrong reason. So if, like the family treasures are in the trust, they are easily protected. So whether married out of community or property or in community is irrelevant, that property will never be attached. And some of these trust babies, they get into what we call frivolous business ventures. So should it go wrong, then that would also be protected. And the other thing that I want to highlight is court orders and other obligations can be incorporated into a trust. So should you die on your death, like the pension lump sum or any lump sum from life cover policies can be transferred into a trust. Okay. Just 1 minute maybe to touch on avoiding conflict of interest. In as much as I'm giving you these options in terms of the business entities that are out there, to run your business. Should you be employed, the first thing that you have to take account of is that you have a duty towards your employer. You have a duty of loyalty and good faith, and you have to devote most of your time and energy for advancing the business interest of your employer. You can't be creating companies that would be in direct competition with your employer. And the important thing is you need to disclose should you be involved in any side business while you're employed. So disclosure is very, very important. It's a pity my time is up. There are very interesting examples that I needed to highlight with what can result to conflict of interest, because it's not only having a side business that do business with the employer, it's also using the same supplier all the time, and in the meantime you know that you're getting kickbacks from that particular supplier. So those are the things that you need to take account of. And I've also thought of the example of there was a case where a guy was working for, was it Vodacom, and he said he started his company. So who owns that IP? Vodacom. I mean, he created all of that while he was in the constant scope of Vodacom. So you can't say, oh, no, but was my intellectual property, I came up with the idea. But if it's so intrinsically linked to what you were doing for that employer at that particular time, unfortunately the IP belongs to the company. And that's it from me, ladies. Those are my contact details.
Thank you so much, Wyna. That was so insightful. One does really need to protect their interest and obviously be careful what you say if you think it's valuable. I'd like to call on Desiree and Wyna on stage.